a presentation on contract drafting for engineers. I'm putting this as a reference for myself more than anything else, but also for anybody who does contracts fairly irregularly, and somebody who's got a technical background. This is going to be a technical presentation, so it's not for everyone. So to start out with, basically standard disclaimer, this is not meant as legal advice. I may be a lawyer in multiple jurisdictions in multiple countries, but I'm not a lawyer in your jurisdiction, nor am I your lawyer. This is also only for lawyers and attorneys. It's not really applicable to the general public. So if you're not a lawyer, you can see it just as a information reference, but you should not try and draft your own contracts without seeking legal advice from your jurisdiction. So there's that disclaimer out of the way. And finally, this is how I do it. This is not how you should do it. You should use your own judgment because the target audience is an attorney with a technical background, so you should do it the way you feel like doing it. And this is just meant as a general guideline. So I generally tend to draft contracts fairly irregularly, which means I keep forgetting all the rules. And I have to keep reminding myself all the rules. So I'm going to basically cover all the rules in the presentation, and then sort of, if you're reasonably proficient at it, you should be able to draft it without forgetting any of the rules and screwing up and causing a bit of headache for yourself and your other clients. So how do we go about drafting a contract? So the way I do it is I basically gather all the facts in a timeline. So which means X happened before Y, so I gather X and Y in that order. You can do it in several other ways, but generally you would start out with the earliest facts and then go on to the later facts in a timeline. And the other thing to do is basically if it doesn't belong in the contract, you can just remove it. It does not affect you, it does not affect the other parties, whoever's in the contract. Then it's just a fact that's out there in the wild and does not need to be added to your contract. Following that, I group all the facts into blocks of facts. So each block consists of a bunch of facts related to each other. So for example, you can have a contract about selling some widgets, and the manufacturing part of the widgets is all grouped together. So you can do it that way. And then you just basically add a short one-word title to each block. So you have a bunch of different blocks, and you basically just add it to each block of facts. And then you draw a box around the money. So you basically just, let me see this pen. Yeah, so I basically just create a block. And this represents my money. So money. And ultimately, that's what a contract does. It's basically a protection for your money, right? So you need to know what's outgoing and what's incoming. So incoming would be things like, somebody performs a service or somebody does something else, and then some money gets deducted from your money supply. So here's my money supply getting deleted. And as the contract progresses, your money supply becomes less and less as your outgoings increase. So think of it like a UML diagram. So it's similar to UML where you have inputs and outputs. So your outputs is your cash. You have finite amount of cash, and your inputs are services basically. And then basically each of your blocks of facts should correspond to something. So it should correspond to either an input or an output. So that's the way I like to structure the basic outline. And you have to get all the basic facts for the parties right off the bat. So you get names, addresses, signature blocks, etc., etc., and then go into the first block. And I'll give a template later to figure out how to do it. So basically the three most important things when you start drafting a contract are the names of the parties at the start, their full exact name, and then if any parties are corporations, make sure you identify the jurisdiction of incorporation. And then you have a background to the contract, so you'll put that in the recital. Under consideration clause, to introduce the body of the contract, you'd say something like, in consideration of the mutual promises or whatever contained in this agreement, the parties agree as follows. That's your consideration clause. That introduces the body of the contract. And I go over the template for the contract later, so you can just copy and paste it basically, or use your own thing. And then we need to know where this contract will be signed. So we need the places to sign and date the contract. That follows the main body of the contract. And then these the attestation clauses should also be appropriate to the parties. So corporate parties might use a seal or an authorized signatory where individuals have their signature as witness. So make sure you put witness blocks and you put the appropriate corporate seal block as well. And then you also start out with a recital. So typically you'll say, the recitals basically are the background and intent of the contract. And it generally identifies who it applies to. They may identify or they may not identify each party, but basically it just describes why the parties want to make the agreement. So typically you'll have one recital for each party. So you say, normally you put each recital on a new line and you caps it and you say party X is in the business of manufacturing widgets. Party Y is whatever, the director and sole shareholder or CEO of Party X. And then Party Z is sole proprietor who wants to resell or he wants to buy the widgets. So you often see contracts starting with whereas. You don't need to use whereas, but you have to title your recital with something. So you can say like background facts or something like that. Obviously, recitals, you don't put any substantive terms in the contract because the substantive terms are always in the main body. So we don't include any facts in the recitals. We don't, uh, because we don't want them to contradict what you put in the main body. So we just basically put any facts that are really important as representations and warranties in the operative part of the contract, but we don't want to put any substantive facts in the recital. You can also incorporate some parts of the recitals into the body of the contract by reference. So you can say something like, party X represents that whatever represents, for example, like statements contained in the recitals X, Y, and Z are true and accurate, or whatever. T, U, A, V are true and accurate. So basically, you have to make sure that the recitals should be consistent with the main body of the contract, and differing jurisdictions have different opinions on that. But yeah, keeping it consistent is the best. And then we basically, we create an outline for this document. Like I said, I've put a template in there. You can put a template. You can copy and paste the template and just use that sort of as your outline. And then you basically put the information in the contract as a basic, in the template as a basic outline. So you can say something like, the actions each party has to perform, basically the performance of an event to which the parties are contributing, the ongoing relationship, which will have stages. For example, stage one is manufacture of the widgets, stage two is delivery of the widgets, etc. And then basically number of questions which the parties will confront. What happens if the widgets are late or the widgets are not manufactured properly or something like that. So that's basically your template filled out, and you've basically got all your facts. You've put it in there, and then you basically do, you basically make a pattern out of each piece of information. So you'd say that each piece of information is organized chronologically, or you can do most important to least important, or you can do what affects what. You can do it whichever way you want. Chronological is I found the best way of doing it, but you can do it however you like. Um, you can do it like most frequently to least frequently, permanent before temporary, and then substantive provisions. However you do it, keep it consistent, and then you can do it. You can do it either way. The next stage we have to do is organize the contract. So we start organizing the contract with two different ways. So we can organize it as rights and responsibilities of one party and then rights and responsibilities of the other. It's called partisan organization. Examples of that are like landlord-tenant agreements. You can also do it topically, which is by subject matter. And these are the two, so for example, you can do a performance-based contract, such as, agreement to build a house or stage an event or whatever works for you. That's a topical organization. So those are the two basic ways I know of how to organize contracts. Once you have selected the structure, then you'd basically start out by organizing all the headings and numberings, because now we've got our template. We basically put facts in there. So now we want to do all the headings and numberings. So you've got to basically keep a consistent numbering system, and then for example, we do one as section one, and then A as subsection A, and then small one as a paragraph or a clause of subsection A, and we organize it that way. You usually start out with capital one, small a, and a small one, and do it that way. There are other ways of doing it. You can do, as long as your numbering is consecutive and subparagraphs are formatted correctly, it's fine, as long as it's clear to the reader, basically. There is one caveat about your headings. So the legal impact of your headings do cause different interpretations of your document. Some legislations in some countries says otherwise, but in general, as long as you keep it consistent and keep it short, the courts should just interpret the headings only as a helpful guide if your text is ambiguous. So make sure that your headings are consistent with your text that you put in there. The next slide, let's go. Yeah, so the next slide is how do we keep in mind that the contract intent is the the main rules of interpretation are always to be kept in mind when you basically check your contract. And basically, generally in British common law, we assume the intent of the parties. It basically follows the ordinary grammatical meaning of the words. The whole contract must also be read as a whole, so the language of one section may or may not affect the construction of another section of the contract. Context does matter, so contracts are always construed by the courts in a way that's consistent with the facts as well as the timeline when the document was created. And then, if specific provisions of the contract are inconsistent with general provisions, those specific provisions prevail only for the purpose of resolving any inconsistencies. So, as an example, a contract may say that, um, you may not carry a bottle of water onto a plane, onto an aircraft, but then it may later say that, for example, bottles of water are allowed to be carried on if they're used for the purpose of feeding an infant, for example. So the courts will not interpret it as, anybody who with an infant can carry a bottle of water on the plane. They'll interpret it as if the infant requires feeding during the plane flight and the flight is, for example, above 1 hour or 2 hours, then you can carry a bottle of water on the plane. Does not also allow like anybody to carry a bottle of water on the plane. There's also an ambiguity where if you can resolve it, the courts generally tend to favor the party who's not drafted the contract over the party who has signed the contract. So, for example, if you create a standard form contract and everybody has to either sign it or not choose the service, courts will take any ambiguities in the contract and say, this will be resolved against you because you've done a standard form contract, and that will be drafted against your favor. So, and then the other thing is when the parties name particular items of a class, but do not name others and do not specify that the particulars are any possible examples, or for example, if the person is not named, the courts basically interpret that as favoring only the named persons or particulars. So a contract which says, if my trustee is unable to act by reason of death or disability, it does not apply to other reasons while the trustee might not be able to act. However, if the contract says, if my trustee is unable to act for any reason whatsoever, then it's a general blanket coverage. So it does get covered. And finally, the courts also say when there's no ambiguity, the parties clearly agreed on the terms, the courts will not rewrite the parties' bargain, which is included in writing in the contract. So, a court will not overrule you if there's no ambiguity. So that's basically the broad common law, and it may vary in your jurisdiction, but that's generally the common law intent of the parties, which is used by most courts. So we go to the actual meat of the contract. So we got a whole bunch of different types, and you can have a look at the basic things on the screen, which is covenants, representations, and conditions. Covenants are basically, promises to do or not to do something in the future. And they're usually created by like must, will, shall, etc. So generally, must, shall, or will is usually the words which create covenants. So representations basically confirm a state of affairs exists. So one party might represent that the widgets are in good working order or not subject to claims, and then the other party relies on that accuracy of that representation. So, Brau represents the house can be used to host a party, etc., etc. Then we have conditions. We have condition precedent. So, which is basically conditions are promises to do or not to do something if a particular situation or event occurs. So, there are basically three types: there's condition precedent, there's condition subsequent, and there's a conditional promise. And the condition precedent is it says basically that some situation or event has to occur before the parties have any obligations under the contract, and this condition basically benefits one party. The party can waive a condition precedent, so I can say like you know condition precedent to inspecting the widget is whatever third party QA has approved it. So that can be waived. So like I can say that third party does not need to inspect the widgets, and I'll just take them as they are. Next slide. And then conditional promises basically says if some situation or event occurs, then a party has a right or obligation to do something. So if the situation or event never happens, then the right or obligation never expires. So it never arises, sorry. So example is, of course, if X happens to Y by certain date, then, X will do Z to something else. So that's basically a conditional promise. And then condition subsequent is basically a termination clause. It says that if some situation or event occurs, then the contract comes to an end. So basically, you give written notice, the contract comes to an end. But it may happen or it may not. So that's only occurs if that particular situation arises. And then we have statements. So statements describe rules or premises that all parties agree on. For example, we have the usual time is of the essence. And then we have rights. So, the rights basically give parties permission to do or not do something. So, party X may do quality assurance on the widgets. Or, the buyer may inspect the car to see if the seller has removed the dashboard in the car. And finally, we can, add. Basically, we need to know who, what, when, where to the facts, and also how, if required. So that gives us the basics of all the terms in the contract. Things to keep in mind as you work your way through the contract is to use legislative sentences. So, for example, employee X will get paid by the first of the month. That's not a great example of a legislative sentence. So instead, we say the bank, which is who, will pay the employee's salary, which is your action, to the employee, which is basically to whom, by the first day of each month, which is, when, um, at the offices of the bank, which is your where. So that's how we write legislative sentences in the contract. We always have who, what, when, where, how. How is optional, of course, because you can say by check if you, for example, is a how, but it's generally optional. Things to keep in mind with your legislative sentences is make sure you do not use one sentence to confer two types of obligations or different obligations on different parties. Keep it short, to the point. Use the who, what, when, where, and optionally how to basically create your legislative sentence. So sometimes you can do you basically can't specify who is doing the action. So for example, if you have a declaratory enactment, interpretation clause, and or a definition, then you don't need to have a legal party as the subject. In this case, you would use passive voice or frame your terms as statements. So you can say that costs of administering this legislation are to be paid from fees collected by the legislation, or this agreement is to be construed according to the laws of whichever jurisdiction you're in. So that's basically a legislative sentence without a legal party as the subject. So all right, so here's a template of what a contract should look like. It's an example template. So we start out with this agreement dated for reference between party 1 and party 2, and background facts. We put all our background facts, A, B, C, D. And then we say, in consideration of the mutual promises set out in this agreement, and we say 1, 2, 3, 4, 5, and subheadings as we discussed earlier. And then we finally end it with parties executed this agreement, where did they execute it, and then corporate seals or signatories with the witness. And then you'd say name of witness, address of witness, occupation of witness. When you're specifying, for example, definitions, you have to be pretty clear what you're defining. So definitions can be either descriptive, which is basically you have short forms to refer to a person or subject, or it can be stipulative. So you're using them to capture a concept. So basically the general rules and definitions are you define words as they're used. You don't define terms unnecessarily, so you don't create definitions you won't use again or state obvious stuff. So if you're referring to a person by name, you don't define them with their title like Mr. or Mrs. or Miss. You just refer to them with their title and their last name, or define them only using their last name. So in all our definitions, for example, here we've got Acme Inc. So we defined them as Acme in the first bit of it. Where's my pen gone? Let's see if I can. Yeah, there's my pen. So yeah, so here's my definition of Acme. And then I defined Victor as Victor, basically a business person. Uh, when you define it, you say the term. So, for example, you say X and Y started a company called Acme, and then you define Acme following that. You don't want to use too many definitions. You also don't want to use circular definitions. So if you defined Acme as Acme here, Acme is widget called, you can't call the widget made by Acme as Acme because that's a circular definition basically. And you don't want to use external definitions. So you don't define a widget as this widget has the same meaning as the widget we defined in our last agreement dated for reference January 1, 1970. Because we don't want each contract must be closed, basically. It must be a closed um, document, so it should not refer to other entities. So any fuzzy entity in the cloud, like you have a second contract out here made earlier, we don't want contract 1 to depend on contract 2 because then you're incorporating by reference, so you don't want to do that. And then you want to avoid using substantive terms in your definitions. So you don't want to presuppose matters which are in issue in the contract itself. So you don't define, for example, termination meaning dismissal for just cause on 2 weeks notice if your text is about what also might be just cause for termination. Make sure you define, these are definitions, so make sure you define, your definitions should be something that has an ordinary meaning. So we don't want to define things as not having ordinary meanings. So you can define Acme Inc. as Acme, but you don't want to define Acme Inc. as, buyer or something like that. Or seller or something like that, because legislation does refer to buyer and seller, so you want to try and avoid things which cause confusion for the reader, essentially. And then you need to be consistent. So wherever you see Acme, it needs to refer to Acme Inc., the company with the registered office, and not some other company. So make sure you don't. Make sure you do consistent definitions of anything you define. And then finally, try and avoid using a definitions section. You can, but unless you're defining a really lengthy contract, I would avoid basically having a separate thing which says definition dropped in here somewhere. So basically, you can have different methods of defining definitions. You can use a synonym. So, for example, bruise means a contusion. You can categorize or subcategorize when you're creating definitions. You can say newspaper means a document, which is a general category. Or you can say, newspaper means a document containing remarks or commentary on current events. That's a subcategory of a general category. You can add on prepared for distribution to the public, another subcategory that is published periodically, and then that's another subcategory, but no often less than monthly. So that's a subcategory of documents which are published. You can define the larger context in which the defined word is a part of the context. So, pulley and block and pulley means part of a mine hoist, for example, or a hoist or crane. And you have to list all the things to which the definition refers to. So you could say local board means any school board, public library board, or whatever you like. And the definition is always in the same grammatical form. So you can say something like revocation means cancellation. But avoid using something like revocation is when any contract is cancelled, because that would be basically a poor example. Because you're not referring to any contract here, it just means cancellation. If you're stipulating something, then you have a stipulative definition. You have to be clear on the scope of the definition. So motor vehicle basically includes motorcycles or bicycles powered by motor and capable of transporting a person on a high speed road, for example. That's an inclusive definition. You can have exclusive definitions as well. You can define delivery time means any time within 24 hours after the train arrives at the railway station, for example. You need to be really careful when you're defining things that you don't join items with an and. So, for example, trading means buying and selling. That's really bad because you haven't defined what it is. You've created um, a contradiction. So you have to buy and sell in order to trade. But if you say something like trading includes buying and selling, so that would be a good example, because that's either buying or selling. If you want to define things which are conjoined, you should specify something like trading means buying and selling, but not buying or selling alone. So that would be a conjoined definition. And then your language also has to be consistent. So every time you use consistent meanings, consistent definitions, you have to keep it always consistent throughout your contract. Same thing goes for numerals. So if you want to spell out numbers, generally so here's an example of my numbers. So I have a zip code here, I have my year here, and then I have a date here. So in the contract, you basically keep it to the normal rules, which is you spell out numbers of 10 and under, and then use digits for larger numbers. So 2 50-gallon drums, or 3 children all under the age of 18. So 18 would be written out as 1-8, and then 3 would be spelled out as THRE. For your drums example, 50 would be written as 50. So in general, you spell out large round numbers like 1,000 or million, You always use digits for addresses, phone numbers, page numbers, and where the original source was a numeral. So like a movie Terminator 2, for example. You would spell out approximate numbers, so around 20 widgets or 100 items. You would use digits where multiple numbers appear close by, because we are putting some of them in numerals and some in digits that look inconsistent. So we use digits where multiple numbers are close together. And in strings of calculations and measurements, we'd always use digits. So um, he weighed 500 pounds, whatever, you put 500. And then you'd never start a sentence with a numeral, and then you never duplicate written amounts with digits in parentheses. So you never put like 5 FIV and then put 5 because it's redundant. So we don't want to put like number 2 Moon Street as 2 and then 2, because that would be inconsistent. It's redundant, so we just want to put 2. Percentages, you just put a percentage symbol. As long as you keep it consistent, you can use a percent as a spelled out spelling. And currency, you put consistently, same way you put $1 million as MILLION. You don't need to put it 1 followed by 6 zeros. And you don't need to put cents either, because if there's no cents, then there's no point putting cents there as well. For a foreign currency, you'd use 500 CAD, so CAD, or 500 USD. USD is also fine, as long as you keep it on the same line. Otherwise, that would interfere with the clarity of the numerals. The other thing to keep in mind is to avoid vague terms. So we want to be on point as much as possible. We want to avoid things like X will give Y reasonable notice of Z if possible. We want to avoid that. So what is reasonable notice? Why is, what is reasonable for one person may not be reasonable for another. And then vague terms will always favor one party versus another. So if courts interpret a contract which has a vague term, they'll interpret it against you because you're the one who drafted it. So your opposing party might say, for example, reasonable notice would be like 6 months, while your version of reasonable notice would be like a week. Provisos are another thing you should keep in mind. For limitations and exceptions to a clause, sometimes provisos have to be vague. So we want to generally try and avoid using provisos. So a simple proviso example would be, the bank may issue notes payable to the bearer on demand, provided that the bank does not issue notes during a period of suspension. And that's a proviso which is vague and ambiguous. It places information in the wrong place, basically. So the better way to rewrite that would be something like the bank may issue notes payable to the bearer on demand except during a period of suspension. Prepositions. Make sure you don't miss any prepositions. Terms basically become vague when prepositions are omitted. So a really bad missing preposition is, for example, to the children of B and C. A better one is to the children of B and to C. And then the even better one is to the children of B and the children of C. So you can see the difference between a missing preposition, because you can interpret it either way for the first example, and then you have to interpret it correctly for the second and third example. And avoid and/or in your terms because they're vague and contradictory. So you have to basically, instead of saying and/or, you rewrite it to say exactly what you mean. And means both, and or means either. So make sure you handle them correctly. When you're writing a contract, you also make sure that there's no passive voice. You want something like passive voice is basically obscuring who's responsible for performing the action. So we want to avoid passive voice in legal instruments, basically. We want to make sure that it's always active voice. So you will say something like passive voice is like sick leave will be granted to employees, and active voice will be the employer will grant sick leave to employees. So it makes it very clear that somebody is granting sick leave. So remember that who, what, when, where, why. It's the same principle, basically. We do use passive voice only in certain legal instruments. We use it in mainly as legislation. So we say a license issued under any enactment repealed by this legislation is considered to have been issued under this legislation, or this legislation may be cited as the criminal code or something like this act will be considered to have come into force on January 1, 1970, or when other laws complete the enactment. So the employees who are to administer this legislation will be appointed under XYZ legislation. But in our contract, we generally just use active voice. We don't use passive voice, because passive voice leads to a lot of problems. It can lead to false imperatives or terms that can be obligations, but in fact obligate no one. So passive voice is really bad for contract writing. Next slide is, yeah, so we basically fill out the template, add your facts to it, add the obligations and the monetary flow to it, and then basically drop it into your draft of contract and then revise your draft a couple of dozen times until you get it to where you want it. A couple of other things to keep in mind is always use present tense. So since we are consistently speaking at the time of the creation of the contract, we always use present tense. The exception to that is, of course, wills or conveyance. And then all our legal instruments are consulted when readers want to know what the current rules are, so the provisions are always drafted in present tense. Some of the obligations may be in future tense, so for example, X shall pay, and some may be in the past. X represents that she paid or he paid. So that you can't avoid, but in general use, you will use present tense for most of the contract. Other things to keep in mind are set clear time periods. So you have to be clear where, for example, you write within 2 days. Does that include only the number of days? Do you mean 48 hours or before midnight on the second day? Similarly, in 7 days, does that include the first and the last of the 7 days? or a month. It doesn't mean a calendar month or 30 days or 31 days. And then, if you write out your dates as numerals, 407, does that mean April 7th or July 4th? So that you have to be very clear in your dates. So if you want to have something which occurs on a date, you'd say the buyer will pay the seller on January 1st, 1970. Or if you want to have it before that, you'd say buyer will pay the seller by January 1st, 1970. Depending on your legislative, on your particular area where you're actually going to have the contract interpreted, there's usually an act or rules which go over exactly how the time periods are interpreted. Make sure you read all the statutory language in your particular jurisdiction. And then common law for dates. So common law for dates is basically if you say a period of time begins on a certain day, that day is included in the time period. And a day is considered a period of 24 hours at common law. Again, depending on jurisdiction. A month used to mean 4 weeks, but there's different courts have interpreted differently. So in some legislations, month means a calendar month. So you've got to figure out which, uh, or you specify the exact dates. But you've got to specify which interpretation if you're going to just write month. Normally, a calendar month is usually calculated from a day in one month to the corresponding day in the next month less one day. So, June 15th, a month ends July 14th. So to avoid any confusion, you have to define your meaning. And then a year is, again, at common law, is 12 consecutive months, starting on any named day. So 365 days or 360 days, 66 days in leap years. So again, you're better off using something like ISO 8601 format for all numeric dates, which is 4-digit year, 2-digit month, 2-digit day. And that creates consistency, but it depends on the court system you're writing your contract for, so they might have a different take on it. And you can see that, where we've written, let's see, the previous slide, where we've written January X, and then 4-digit year. So we kept it consistent. So make sure you keep it consistent throughout your contract and then specify the exact date. So similarly here, you also want to avoid complex sentences when you are doing your contract. So we want to basically avoid sentences like, for example, applicant tenants may apply for a housing credit within 30 days of taking possessions of dwellings that are apartment, condos, detached homes if they're owned by the company. So that's a complex sentence. So we want to make a simple sentence. So we say something like, tenant of a dwelling may apply for a housing credit if these conditions apply. And you say A, the dwelling is owned by the company, whether it's an apartment, condo, or home. And B, the applicant applies within 30 days of taking possession. So try and write in short sentences, keep your subparagraphing very brief, and the more levels of subparagraphing you create, the more difficult it is to follow. So make sure you avoid doing that. Cross references are also good in some areas, so you can do cross references. But you basically have cross references for cleaning up and making the contract more consistent and concise. Basically, you want to avoid creating confusion, and cross references often create confusion. So you say an inspection in accordance with the terms of clause 20. You can define inspection requirements basically at the start of the defined term and then do it that way. So unless cross references are absolutely necessary, don't use them because they add unnecessary complexity to your contract. So you can say that in some places, you can say for excluding or limiting the application of a provision, despite subsection 20, or without limiting the rights of XYZ under section 20. Or, for example, you can say if you want to incorporate a provision by reference, then you say as stated in clause A of the background facts. So that's a good example where cross references are suitable. You can say something like, if you want to put subject to paragraph 10, you can say subject to the notice section. So that avoids unnecessary and makes the cross reference a lot simpler. So you need to be completely tight and precise with your cross references because they do cause issues later. So we've covered defining the terms, we've covered numbering all the paragraphs, subheadings, headings, we've covered that. Let's see, what have we left out? So we covered some of the background facts that we did. Generally, we try and do must instead of will and shall because that's the modern way to do it. You can still use will and shall. And finally, you need to make sure legal consequences flow from it. And otherwise, there's no point adding it. So that goes back to, we have a box with your money in it. Money and things which come out of it and things which go into it. And that's basically what your contract should be. So unless something legal consequence basically flows from it and the parties care about it, it shouldn't be in the contract. So that's about it for contracts. For a drafting checklist, basically check if your draft harmonizes with, check if your draft harmonizes with related documents like statute law, common law, etc. Make sure there's a sanction for every contravention, which is again going back to your outflow and your inflow. Let me go back to pen. Yeah, so that goes back to your outflow and your inflow. So every time this is contradicted, you make sure you have a sanction attached to it. So money comes in instead of going out. That's a sanction. Or there's some sort of thing which is some sort of punishment for the other party, basically. And then definitions, you basically check, are they needed? Is there anything substantive in them? Can they be moved to the text if they're not already in the text? So do we really need this definition is what you should be asking. And then cross references. Are they all needed? Are they precise and accurate? Overall contract organization. Is there a clear structure in your contract? Does the logic flow in a pattern basically the reader can read and see? Does the logic apply equally to the whole contract, to parts and sections of the contract? And then each section, does it contain one legislative thought? Are the sections short? Are they straightforward? Are they distinct? There's no repetition between each section in the contract. And then have you used ordinary meanings? Are there any synonyms, inconsistent diction, or superfluous words in your synonyms? Does the text use active voice and present tense? And then in your headings, do you clarify the organization of the contract? Are they concise, simple words? Finally, there's punctuation. Is it accurate and consistent? And does the punctuation assist in clarifying the meaning of the contract? That's basically what you need for a great agreement. That's about it. So it's not that complicated as long as you keep all these in mind, and hopefully that was helpful. And that's about it. See you.